Hi, I'm Paul Melnick, and I'm an attorney practicing in Tysons Corner, Virginia. My area of practice is real estate, estate planning, and estate and trust administration.
And I'm Jim Cox. I'm an attorney at Mickey Hamlin in Charlottesville, Virginia. My practice is very similar, estate planning, estate administration, and real estate. I suppose that's why we've been chosen to be part of the living library, the real property section of the Virginia State Bar, in order to try to bring some information to practitioners about practicing in this area. We decided that we're going to focus today on this topic on really what happens with real estate in a decedent estate after someone's deceased. We've had our own individual presentations on things that happened during one's lifetime, but we thought this would be a good topic. Totally unrehearsed, but we hope this will be informative, and I think both of us will be available for kind of any communications that people have by email or phone after this if you have particular questions.
Mm-hmm. Right.
So one thing I always like to talk about at the beginning of any of these programs dealing with a decedent's estate is to make sure people understand that this is going to, when you're dealing with clients, you're typically dealing with the family of a deceased person, whether it was somebody who was had been ill for a while or sudden. Either way, it's a very traumatic experience for the family left behind, and so you need to always be cognizant of that and be understanding of their needs and their issues at that point in time. I've always said that this is kind of where the counselor at law, your bar certificate says attorney and counselor at law, and this is one area where the counselor of law is really important to focus in on, just to make sure that you're, giving them good counsel as far as things, and not just, black and white letter issues as to deal with on the law. But having said that, one of the first things that happens when you're dealing with an estate that has real estate is what steps need to be done in any sort of public administration of the estate. And by that, we typically mean probating a will or filing documents in the clerk's office of the circuit court in which the decedent typically last resided, or in which they had, which the real estate is located. And a little depends on whether someone died leaving a will or died without a will, which is called intestacy. And either way, there's steps that need to be undertaken in the clerk's office at that time, and there is oftentimes some time lag. So again, if you have a particular real estate transaction that is time sensitive, you may need to make sure people understand that things can't happen as quickly as it might happen in a transaction during lifetime. You have to typically make an appointment with the clerk and provide them certain information in order to qualify either as executor, probate a will, or file a list of heirs. And so just generally, just to talk broadly about the issues, obviously there's a lot of steps that have to go through an administration process. But if you have a will, it's usually you need to bring the original will to the clerks, and then other information to probate that. And that's and that will be a focus of how the asset passes at time of death. If you die in an intestate situation, it is a little different and a little curious, is that in those circumstances, then you simply typically file a list of heirs. If the only asset you're dealing with in that particular jurisdiction is a piece of real estate, then filing the list of heirs confirms who are the owners of the property by virtue of the decedent's death. To get back to this kind of fundamental issue, maybe you want to talk a little bit, Paul, about the concept of assets or real estate dropping like a rock at a decedent's death.
Yes. So that's something that law students, as soon as they take estate planning classes, they learn about property dropping like a rock. And what that means is that Virginia is very historical with real estate, and it's highly respected in the law. And the idea is that it goes straight from the decedent on the moment of death to, if they're intestate, to the heirs at law, and if they have a will, to the beneficiaries under the will. And it doesn't skip anything, it just goes straight to them. And there's there's ways of diverting that, and those are with powers of sale, and it could be a power of sale with an added interest. It's a super added power of sale, and what that is, so the typical dropping like a rock and going either to the heirs and intestacy or devisees under a will is that they get the use of it. Like if the power of sale is what's called a naked power of sale, and that doesn't include the executor, and they have the use of it. And if the will gives a power of sale to the executor, then the executor can divest them of that interest that dropped like a rock, and so it divests. And that's the principle of that. And the super added power of sale is when the property is actually divides to the executor to sell. And that was mentioned by Jim in his individual video.
Well, one thing that's always important is to investigate how assets are titled, particularly the real estate at time of death, because there are a lot of different options, and as I said, things will vary depending on your decisions on the estate will vary on that. Obviously, people are very familiar with spouses owning property as tenants by the entirety with right of survivorship. That the form of the deed, the titling the deed controls that disposition, so it's not part of the estate in the same and that way in the same way if the deed says joint tenants with the right of survivorship. So it's you really have to go back to the source documents to see how that is. And of course, you could have somebody who has a fractional interest in the property and they own a half interest in the property, and you still have to deal with that in those circumstances. Paul, in his talk, highlighted the new option that people often have in order to avoid probate by the use of a transfer on death deed. And again, you have to investigate and look in the clerk's office to see if a transfer on death deed was in fact properly filed and recorded before the decedent's death, and who the beneficiary is under that. Because again, if that's done correctly, that's not something that goes through probate. You don't have to pay fees on that, which is one of the goals on that. One of the issues that comes up with real estate, unlike other assets, if you have a bank account or a stock account or investment account, that's great. Those are assets that are readily turned into cash. One of the problems with mortgages, one of the problems with real estate is they have certain expenses and costs associated with them, and so somebody has to be ready and available after the date of death in order to pay insurance and taxes and utilities and keep that property up until you decide whether and how to sell the property. But ultimately, there are some times when people want to hold on to the real estate, and that's as either it was specifically devised to somebody and they want it, or one family member buys out somebody. But in most cases, most cases now, people are looking to sell the property, and usually sell it pretty quickly after the time of death because of the fact that there are expenses associated with it, and there may be a mortgage that is due. So what are some of the issues that people have to deal with at the contract stage and looking to sell property in a decedent's estate?
Okay, so when there's property in a decedent's estate, and either the executor, if the executor has the title, like I was saying before, whether divesting the devisees of the heirs of the property, and that's and a caveat is that in intestacy, an administrator doesn't have a power of sale off of that. They have to get it from a court. They have to petition a court for it. But with the sale, so I'll assume that the executor or the administrator does have the power of sale, and that they are going to sell the property, whether for convenience, if the beneficiaries, all agree that it should be sold. Even though that's not necessary, it's helpful to avoid litigation in the future. But so assuming that the executor administrator is going to sell the property. So this is particularly perilous in an estate atmosphere because, first of all, the executor administrator may not be familiar with the property. They may not know the quirks of it, or problems, or defects, or anything like that. So that's one perilous thing. The second is that a lot of times they're just thrown into this, and they just want to get it over with as quickly as possible. And that makes the attorney's job a bit more challenging, just to get them, to be patient, to go with the process, to take the care that it takes with the contract. And the attorney's job, in large measure, is helping to protect the executor in the estate from excess liability. So with the contract, the overriding thing, in addition to what I've just said, is making sure that it's clear, making sure there aren't ways that purchaser can get out of the contract, due to something not having been done, that there's not ambiguities, that there's not fluff, whether on the contract or on settlement documents that create extra liability for the executor administrator. And some of the high points are watching out for, in contracts with the estate not appearing correctly, or the executor administrator not appearing as a fiduciary with that title. Sometimes with electronic signatures and everything else, they just appear individually. But that's a problem because they're actually acting in a fiduciary capacity. So checking that the buyer business is actually in existence. Checking that the settlement agent actually is licensed. Because sometimes LLCs, they may not even be set up during negotiations. And maybe they'll be set up right before the contract is signed. And so staying on top of that's important, because a contract isn't valid if the buyer is not even in existence yet as a business entity. Making sure that the contract has the right property address, legal description, tax ID number. Making sure that the deposit, the earnest money deposit, is handled correctly. What I do, if I can, is I have the contract state that our office is going to hold the earnest money deposit. Because if it's forfeited, that makes it all the more easy to actually have it forfeited and paid to the seller, instead of it being caught up in a settlement agent picked out by the buyer. Vague terms should be avoided, like business days. Like, what does that mean? Things like that should be defined. The attorneys should be listed among the notice provisions with the attorney's email, and then in capital letters and then the buyer. I'm sorry, then the seller who the attorney represents. The Virginia Residential Property Disclosure Act, that's an act having to do with disclosures, and most of it says there aren't any disclosures. The one disclosure has to do with building permits. But fiduciaries selling from a decedent's estate are exempt from the act. And so a lot of times offers come in from buyers and they have that form. And it's unnecessary and inadvisable for the fiduciary to sign it, because that's not necessary. It's taking on something that shouldn't be taken on. And the condo package or HOA package should be ordered ASAP, so the buyer can't get out under that provision, allowing the buyer to cancel pending getting the HOA or condo documents, or however many days after that the contract states. There should be an as-is provision, because why would the fiduciary want to take on more responsibility than is necessary? In a short story about as-is provisions, so if I can do it, I have the as-is provision effective as of the settlement date. In other words, whatever the condition of the property is on the settlement date, the buyer has to take it. And believe it or not, I had a case where the fiduciary seller was allowing a friend of the family to go in and take things like copper pipes, you name it. They were cleaning the place out, and the buyer allowed it. But a gas line was severed, and fire engines showed up and everything. This was the night before settlement. And so I hear about it the day of settlement, but fortunately I had the as-is provision in there. So there was no argument about it. Broken gas leak, there wasn't a gas leak, there wasn't a fire, but it was still probably a pretty expensive thing to fix, and it was damaged. But the long and short is that the buyer had to accept it as the condition on the settlement date. So that provision saved the day, and the settlement went through. We didn't even hear from the buyers about it. So make sure if there's an assignment provision that the buyer remains liable under the contract until settlement, and that there's written notice to the seller about the assignment, so that at the last minute there's not an assignment that the seller didn't even know about. During the study period, it should state that the buyer has the onus to terminate the contract. If there is an access provision for a study period, there should be a strong indemnity and hold harmless. And that's so that the estate's not on the hook in case a worker gets injured due to some defect in the property. And also, it's important to have a provision that the seller can leave anything they want. And that's with builders and investors. They don't care because they're going to tear the property down. And that's especially important with things like pianos and basements that could be expensive to remove. There's a number of statutorily required provisions. And if you need those, just give me a call. But in most form contracts that you can find from reputable publishers, they're all in there in the contract. But a lot of them are important because if they're not in there, there could be issues. Damage limitation provisions are important. Like if the seller breaches, just return the deposit and the buyer gets specific performance. And also no blank lines or boxes, because that just leads to ambiguities and then possible litigation later. So those are the main points about contracts, unique to the fiduciary sale arena.
A couple things. Yeah, excuse me.
Oh, yeah.
A couple things I would just add is, again, it all depends on who the proper seller is following the decedent estate. If it's the executor, it's important to list the contract and the name of the executors. Don't use estate of John Doe. Technically, in Virginia, there's no legal entity called the estate of. It has to be Jane Doe, executor of the estate of John Doe. Obviously, if the property drops like a rock to a specific beneficiary or a couple beneficiaries, and they're selling it as opposed to fiduciary, then the contract should be in their names. And again, that's all going to depend on the terms of the will, if a will's at play in those circumstances. That's why, you talk about estate issues and estate planning issues. You always go back to estate planning issues. It's always important to make sure that the will is set up that if you want the executor to be the person who sells it, and it's more effective for them to sell it, that would be great. I just had a case where I had to, convince a title company that the executor could sell it instead of having the 17 named beneficiaries, because it didn't say I give the property to the 17 named beneficiaries. It says my executor shall distribute the proceeds to the 17 named beneficiaries, and so it was clear in those cases. But you can, if you have those kind of multiple ownership issues, you might be an issue. I like your idea about leaving the tangible property. A big problem for most people in trying to get property ready for sale is getting it cleared. I mean, most contracts say things will be left in broom clean condition, and just getting out, especially if the decedent was a hoarder, getting things out in a fast time is always problematic. One other issue is always making sure you still, after the decedent's death, you have homeowners insurance in place, which is not always as easy as it seems, because sometimes insurance companies don't like to insure property that's unoccupied or doesn't have somebody watching it. So you have to make sure that that's going to be the case. Why don't you give, the title company usually has a couple extra requirements depending if you sell a property within a year's period of time. Why don't you give some thoughts as to that?
Yeah, so what that's all about, what Jim's referring to, is this year period. So it's a period of time when creditors can make claims against the estate, in particular against the executor, or new wills can be found, or the probate of wills can be appealed. Any number of things can happen within this year. And so what title companies do, most contracts say that the property the title should be good and marketable without any special risk premium, that sort of thing. And in order to make the title good and marketable, the executor needs to take care of this problem and make it insurable. And so what that's all about is, in order for the title insurance company to insure all these various things that I just mentioned that could happen within this year, some within a year of death, some within a year of probate, then there's a thing called an extra hazardous risk premium. And that's typically, from what I've seen, $2 per thousand of the sale price. And that's paid by the seller And that is in lieu of waiting for the year to pass from date of death for the proceeds to be released. So it's either an escrow program with the title company, or you pay the $2 per thousand, you get your money right away. And in addition to that, the fiduciary has to sign an indemnity agreement. So not only is the title insurance company getting the extra hazardous risk premium, but they're getting an indemnity. So that's pretty good for the title insurance company if something does happen, because you can see the double backup there as far as elimination of risk. So that's the situation with all the perils that can happen within the year of death.
Yeah. Well, just to kind of round up and close things, then always the issue is where's the money? Everything, where the money? Where does the money go at a closing? And again, it depends on who the seller is and who's entitled to it. If the executor is selling it, it goes back into the estate, which then typically means it's going to be subject to reporting requirements to the Commissioner of Accounts. If it's a sale by the heirs or sale by the devisees, then it should go to them, and any reported income or 1099 will go to them. I guess just as a matter of closing, both of us I think would just want to just tell people who are interested in these practice areas, this has served us well for each of us for a number of years, and we think this is a wonderful practice area for any young attorney or attorney looking to make a shift in what they want to do to go into estate planning or real estate. I mean, everybody I know in Charlottesville in these practice areas is way too busy, so we welcome the competition. So come on in. I don't know whether you have any final thoughts on that.
Yeah. So like Jim was mentioning, this is a very tough time for people, very stressful. There's a lot going on. This is like the last thing they want to think about. And so this is a time for the attorney not only to display their knowledge, of all the legal principles, but also show compassion and actually help people, like in a very personal way, and help them through this very tough time. And so it's very rewarding in those aspects. So we appreciate you joining us for this, and just feel free to reach out to us if you have any follow-up questions.